Good day and welcome to another edition of Q&A Social Security Disability Today. I'm your host, Attorney Reeves, so let's get to your questions. Our first question has to deal with an individual who has exhausted their trial work period, both the extended trial work period and the trial work period, is considering working part-time and wonders how much that part-time work will have on their case. Let me tell you what I tell people. The Social Security regulations created the trial work programs with the express purpose of giving people the opportunity to actually try to reintegrate into the workforce. The simple fact of the matter is, most times they believe that a person who's on disability is not going to be on there forever. And they know that you're going to want to test the job market. But here's the one thing I tell people all the time. At all times, Social Security has the responsibility of determining whether you are still disabled. So I tell people you're going to always, and I encourage people, if you think you can go back to work, by all means try, because you're going to make more money in working than you will be from Social Security. However, I must caution you this. Even part-time work may demonstrate the ability to perform what we call substantial gainful activity. Remember, even if you try to go back to work, I always tell people, don't keep this magical number in your mind. Say if Social Security says, well, $1,000, well, I'll make $999. Don't do that, because at the end of the day, Social Security's responsibility is the determination of whether or not the individual is still disabled. Our second question has to focus on an overpayment where someone reapplied, got approved, and wants to know what will happen with regards to the back payment. Okay. If you have an overpayment and then you reapply and now you are going to receive back pay, what should happen is that that back pay, or at least a substantial portion of it, should be applied to your overpayment. And if there's any monies that is remaining that you still owe, then what Social Security will do is they will garnish a portion of your Social Security disability monthly benefits until that overpayment is addressed. If you know that you have one pending, it's important, meaning if you have an overpayment pending, when you get approved for Social Security, contact them immediately and find out what that impact is. So this way you'll have an idea of how much your overpayment will be slapped onto your back pay and how much will be slapped on your monthly benefits. They're going to give you that breakdown either way, but just in case you want to know in advance, contact Social Security. They'll let you know. Our third question focuses on an individual who has a litany of different conditions, including fibromyalgia, who is curious about knowing what their chances of having their benefits continued under their disability review. Social Security periodically conducts what we call a continuing disability review every 3 to 5 years. It's a rough number, after you've been found disabled. And typically what they do is, at the time they do their review, they compare it to the last time you were found disabled to determine whether you've either improved, remained the same, or gotten worse. The idea is that if you're about the same or if you've gotten worse, you shouldn't have any problems. Or if you've improved, they now want to know whether the improvement has got to the point where you are now able to work. Here's the rule of thumb that I tell people. There's no way of knowing accurately in advance whether or not your benefits are going to be continued in the future, because the reality is you don't know what's going to happen with you tomorrow. Continue getting the treatment that you need, so this way you have medical documentation to demonstrate to Social Security about the severity of your condition. The worst thing you could do is not continue your treatment, because they want to know whether or not you've improved or not. Our fourth question has to focus on the fact of an individual who was informed that other individuals were informed at their hearing of how much money they were going to get in back pay. So the question was, is it true that a judge can tell me how much money I'll get in my back pay at the hearing? Let me tell you one thing. I have never in my 10 years had a judge tell a client exactly what they're going to get. First of all, they usually don't even tell you if you're going to get approved or not at the hearing, under most instances. Secondly, they're not there to calculate your back pay. They're only there to determine whether or not you're disabled. Now, can you get a rough approximation? Sure. Information you get from the Social Security Administration provided to you and your file can tell you that. You can calculate a rough number on your own. However, the judge is not responsible for calculating your benefits. They're only responsible for determining whether you're disabled or not. So if you have somebody who's telling you that they were able to find out at the hearing, more than likely, it wasn't from the judge. It might have been the representative who calculated that for them. But the judge's responsibility is to determine whether you're disabled or not to calculate your benefits. Our fifth question has to deal with whether or not there are laws different with regards to garnishment for child support in different states. Here's what I tell people all the time. The Social Security Disability Benefits Program only allows for garnishment under a very limited number of circumstances. Federal debt's one, alimony for the other, child support for the third. Now, when you're talking about child support, it's going to vary from state to state because every state does things just a little differently, so keep that in mind. Also, every now and then I'll get somebody who says, well, how come I can't get them to garnish SSI payments? SSI is a need-based program, so it's a little different from your earnings. This is a need-based, and in most instances, they typically don't garnish SSI. So if you've got some concerns that there are benefits that a benefit holder is receiving that should be going for child support, contact Social Security, provide the birth certificate and any documentation for that child indicating there's a child support obligation, and they'll take it from there. Our sixth question has to focus on, can I explain the listings? Okay. Under the Social Security regulation, there's 5 steps you have to go through. First is, are you working? Second, do you have a condition that lasts 12 months or more? And then third is, do you meet the criteria of any of our listed medical condition? Social Security has a book that's called the listings of almost every medical condition out there. And typically the question is, do you meet or do you equal? It's a nice way of saying is, here are all these criteria, 1, 2, 3, 4, 5, 6. Do you meet each one? Let me stress this. Very few people meet or equal the listings. It's really hard. I can't tell you the number of times I've had clients who've literally looked up their condition and they'll say, oh, there's a listing for high blood pressure. I have high blood pressure. I meet this listing. And then I have to explain to them, when you go into that reg, there are other things they're looking for. So if you don't have those other things, you're not going to qualify. So just having the condition itself does not necessarily mean you meet or equal the listings. And when I tell you that those listings are very stringent, they are. Because the reason is because it's presumed that if you meet those criteria to the letter, you're deemed disabled unless there's some other information out there to the contrary. So they don't go to step 4 or 5, they'll disable you there. So I hope that helps you get an understanding of the listings of medical impairments. Our next question is focusing on someone who knows about somebody who's using somebody's Social Security number for business purposes fraudulently. And they want to know, what should they do? 2 agencies you need to call, Social Security and the IRS. Because if somebody is using someone else's Social Security number for purposes of business to avoid their tax consequences, they're not only committing tax fraud, but they're also committing Social Security fraud as well. Contact both agencies, tell them that you are aware of somebody, and they'll take it from there. Our 8th and final question has to deal with a vocational expert, meaning, what do I do when a vocational expert at a hearing tells me that I can work? Okay. First and foremost, I need you to understand one thing. The vocational expert is not there to determine whether you're disabled. They're there as a tool to assist the judge in determining how a person's jobs or ability to do jobs would be impacted by various hypothetical scenarios. So typically what happens is that the judge and your representative will ask this person, assume a person who misses 1 day of work, can only work light work and stand for 6 out of an 8-hour day, can sit for 6 out of an 8-hour day, but would have to miss a day out of a month per work. Is there any jobs available? The vocational expert will testify. Well, assume the person can indicate that under that scenario, they could probably do work. Well, let's add a tool to that. Let's say that the person has to miss 4 days a month. Is there work available? Well, under that hypothetical, the vocational expert said there's no jobs. So you've got two scenarios, one that says jobs, another one that says it's not jobs. The judge determines from your medical evidence which one of those two criteria or scenarios meets you. Is it the one that says you can do jobs, or is it the one that says you can't do jobs? So do not freak out if you hear a vocational expert testifying about work. They're not saying you specifically. They're saying a hypothetical person. The judge is the final decision maker and will make that determination as to what scenario closely reflects your situation. Again, I want to welcome you and thank you all for joining me for another edition of Q&A Social Security Disability Today. I want to encourage you to keep those questions coming. We're getting more and more questions on the disability topics line, so please feel free to continue doing that. There's also continue visiting me on the chat line because that's also equally helpful. Feel free to leave a message and I'll address it there as well. Again, I want to thank you for reaching out to me for Q&A Social Security Disability Today. Have a wonderful day, and again,